Good evening, everyone, and welcome back to the AIAC's Islamic Arbitration webinar series. We're pleased to have you join us for the second session titled Across Regions, Across Regimes, Islamic Arbitration in Cross-Border Commerce. We truly appreciate your continued engagement in this series as we build on earlier discussions and take a deeper look at how Islamic arbitration is evolving in today's interconnected commercial and financial landscape. This session will run for about an hour and a half, including the Q&A session. So if you do have any questions for the panel during the session, please feel free to put them in the chat box. So today's session explores how Sharia is applied in domestic arbitration frameworks across different jurisdictions and how arbitrators, institutions, and courts engage with legislative provisions, soft law instruments, and advisory mechanisms such as Sharia boards or councils. The panel will also look at practical considerations in drafting dispute resolution clauses for Sharia-compliant transactions and how disputes are managed once they arise, and the role of institutional frameworks and expert engagement in supporting credible and effective arbitration outcomes. So to guide us to today's discussion, we're pleased to be joined by our moderator, Dr. Faris Nasrallah. Dr. Faris has practiced international arbitration with a particular focus on the Middle East for the past 20 years as counsel, legal expert, and as an arbitrator. He studied Sharia from the outset of his legal training as part of his LLB at SOAS in London. He's also an expert. He has also spent about 15 years as the general editor of the Yearbook of Islamic and Middle Eastern Law, which remains in print. We're also honored to be joined by a distinguished panel of speakers. Each of them brings valuable expertise in arbitration, Islamic finance, and cross-border dispute resolution across different jurisdictions. We now invite Dr. Faris to open the discussion and take us to today's session.
Thank you very much, Safreen, for that introduction and for your very generous and kind words. Assalamu alaikum wa rahmatullah wa barakatuh. Welcome to everyone. Good afternoon to our audience and all attendees who are with us today, and all participants. A very warm welcome to everyone. Before starting, I would like to thank the AIAC for making this event possible, for bringing together such an esteemed panel of speakers, and particularly to Ustazi Nazira and Ustazi Afreen for their brilliant organizational coordination support in making the preparations possible. To start, as a short primer, and this is really to get some of the audience members thinking about the deeper issues that surround Islamic arbitration before we hear from our esteemed panelists. I wanted to note that Islamic arbitration is an umbrella term that denotes a vast array of procedural, substantive, customary, normative, and other practices relevant to the pursuance and performance of arbitral proceedings involving stakeholders that come under or pursue Islamic or Sharia approaches. What is it that we mean by that vast breadth of activity? It can mean various things. It can mean the nationality, the identity of the parties or their counsel. It can mean elements of the applicable national law that applies to the substance. It can be elements of the applicable law on procedure. In the case of the AIAC, it may be the instrument of the arbitration rules, the rules that incorporate the approach that has a Sharia counsel and Sharia compliant aspects in the arbitration. It may be in the identity of the arbitrators. As we'll hear from a number of our panelists, throughout the lifespan of an arbitration, features of Islamic law and Sharia pervade the process, can pervade the process, and often do without us necessarily realizing or being precisely in control of those elements. So I think that's a very important point to begin with. Now, notwithstanding the breadth and the pervasiveness of what I've just said. And given the fact that Sharia and Islamic jurisprudence forms a part of daily arbitration practice in one way or another across the Islamic world and beyond, the term Islamic arbitration, that phrase, continues to be largely stigmatized and is considered as a loaded term. For international arbitration practitioners unfamiliar with that breadth and pervasiveness, the phrase Islamic arbitration wrongly, in my view, conjures up images of restrictive practices, anti-commercial practices, and generally speaking, frameworks of law that are inimical to contemporary commercial relations in one way or another. It also, unfortunately, conjures up images of exclusionism and the reproduction or institution of knowledge and or language barriers that would prevent international practitioners from effectively practicing or engaging with Islamic arbitration. Before I hand over to my panelists, I think it's important to attempt briefly to dispel some of that narrative through a few concrete examples. First, in relation to images of the practice being inimical or contrary to contemporary commercial relations, it's important to recognize that the vast historical Islamic law experience that we have, both textual and practitioner, is in many senses concerned with the effective and productive transnational nature of commerce and global exchange. This is recorded in the Sharia, the fiqh, the imperial codes, the national laws of various jurisdictions, and has actually given rise to hundreds of years of recorded disputes, both in courts and arbitrations, as well as other ADR mechanisms. We don't have time to go into all of the detail, but that framework is incredibly important to give people a sense of comfort that this is nothing new. Secondly, and in terms of the images of exclusionism, the recent history of Islamic law and practice in international disputes is full of examples of non-Muslim practitioners not only engaging with Islamic law, but in many cases, in many jurisdictions, driving the advancement of Islamic law research and Islamic law practice. Two very particular examples here is the prominence of Christian lawyers in developing Islamic law jurisprudence in Palestine and Lebanon over the past century. Again, no sufficient time here to go right into the details, but I point to the late Judge Eugene Koutran, Professor Shibli Mallat of Lebanon, Professor Naila Kumair Obeid, all of which are prominent Christian practitioners that have served in arbitration in various contexts and written authoritatively on Islamic law and arbitration. And the second element is the vast array of Western Islamic law experts and academics devoted to making contributions over the past century to the Islamic law debate. And they include people like Joseph Schacht, William Ballantyne, Wa'il Halak, and so on. The point to be made is a very simple point. And that's that contemporary knowledge of Islamic law as relevant to disputes and arbitration is A, well-trodden, B, highly accessible, and C, driven, at the very least, significantly contributed to by non-Muslims living and working in non-Muslim contexts. So with that said, that's food for thought for the audience. The aim of today's panel is to focus on better understanding Islamic arbitration in the cross-border context, how Islamic law and Sharia travels through the vehicle of arbitration. And as I've said, we've got the benefit of a very esteemed panel with us today. I'll just take a few moments to give you a brief background as to who they are. Firstly, we have Mrs. Hawa Usman. She's the Registrar General of the Nigerian Chamber of Commerce Dispute Resolution and also the General Counsel of the Abuja Chamber of Commerce and Industry in Nigeria. Mrs. Usman has been a member of the Nigerian Bar Association since 2009, is an esteemed member of the Nigerian and international arbitration community. She's a member of the CIR. She has an MBA from Ahmadu Bello University and is a certified ADR registrar. She's previously worked for private law firms in Nigeria and the Legal Aid Council in the position of Chief Legal Aid Officer. She currently serves as the Registrar General of the Nigerian Chamber of Commerce and General Counsel of the Abuja Chamber of Commerce and Industry. And her professional interests include commercial arbitration, mediation, dispute avoidance, institutional ADR developments, and Islamic finance dispute resolution. Mrs. Usman is empaneled with several ADR centres in Nigeria, and the Regional Centre for International Arbitration in Lagos. So we look forward to hearing about the Nigerian experience in particular from Mrs. Usman. We have with us on the panel, Mr. Asadullah Durbury. He's the founder of Durbury Chambers in Mauritius. Mr. Asadullah is a barrister at law admitted before the Supreme Court of Mauritius, is a lawyer also admitted before the Supreme Court of Victoria in Australia. Mr. Asadullah is the founder and principal barrister of Durbury Chambers, where he advises on corporate and commercial law, financial services regulations, cross-border transactions, and Islamic finance. He holds a BSc in Information Systems and an MBA, an LLM, and a graduate diploma in legal practice from Australia. He's an associate of the Chartered Institute of Arbitrators and is currently pursuing a PhD at the University of Western Cape Town, South Africa. Prior to entering legal practice, Mr. Durbury spent over 2 decades in the technology sector and has lectured at a number of universities in London, the United Kingdom, and in Mauritius. In addition to his legal and academic work, Mr. Durbury founded the ILMA Foundation, a not-for-profit organisation promoting education, community development, social finance initiatives. Very, very impressive and diverse set of experiences. Finally, and last but not least at all, is Miss Ria Kamurazaman, who's with us from the Malaysian context. She's a partner at RDS Law. Miss Hurriya is a corporate and banking and finance lawyer with particular focus on Islamic finance. Her practice encompasses advisory, transactional, and regulatory matters, and she regularly works on Sharia-compliant instruments and structures. She's highly experienced in navigating the intersection of Malaysian civil law and Sharia governance frameworks. Miss Hurriya also engages with risk management aspects of Islamic finance transactions, and has contributed to thought leadership in the field of Islamic finance. Ms. Hurriya holds an LLB from the International Islamic University of Malaysia and an LLM from Cornell Law School, together with a certificate of Sharia Professionals Program and Securities at Securities Industry Development Corporation under the Securities Commission of Malaysia. That's a mouthful, and all I can say at the end of that is MashaAllah. Miss Hurriya, this is incredible. So, moving to our first topic, and in line with the overview that I hope some of our audience members found helpful, I wanted to give each of the panelists, starting with Mrs. Hawa Osman, to give each of them an opportunity to tell us about how Sharia influences their national arbitration landscape and the practice and understanding of arbitration in their domestic jurisdiction. So, Mrs. Hawa, if you can give us some insights into the Nigerian experience, that would be much appreciated.
Yeah, Thank you very much, Dr. Nasrallah. And before I begin, I think I'll have to take this opportunity to appreciate the AIAC for organizing this webinar and the opportunity for me to speak from the Nigerian perspective. This is quite important, and like I said, this is something that I have begun to look at in quite some time. So, thank you. So to answer your question more directly, the Nigerian perspective, I need to give a background to how our law operates in Nigeria, because the Nigerian legal architecture might be different from what we have globally. And without understanding it, it will be difficult to make sense of what we're talking about. So Nigeria is a common law jurisdiction country at the federal level. And we also have constitutionally entrenched Sharia courts operating in the 12 states of the 36 states and the Federal Capital Territory that we have. But specifically and essentially, those courts, by the jurisdiction of the Constitution, can only exercise jurisdiction over personal law matters, Islamic personal law matters. And this could include family, inheritance, marriage, and generally personal status. So, but commercial disputes in the context that we'll be talking about, or in the context of Islamic finance, has not been clearly put together or as the jurisdiction of the Sharia courts that I have just mentioned. And moreover, like I said, we have this in just about 12 states of the Federal Capital Territory. So this is essentially the landscape, right? And this is where the tension lies. Because what will happen, or what that means in practice, is that the Sharia influence on Nigerians' habitual process is almost entirely contractual and consensual in nature, not institutionally or statutory, as it were. We also have the federal high courts, which have jurisdiction over banking and financial institutions. But what we'll discover later in this conversation is that these courts might not, the judges in these courts are trained under common law and not necessarily the Sharia or the Islamic finance, as it were. So what it then means is that if someone is confronted with a dispute, for instance, a Sharia-compliant banking transaction goes wrong. For instance, if in a Murabaha arrangement or an Ijara financing or Misharaka partnership, the party is seeking resolution, then it means that the party has to go to a civil court. And before a judge who is entirely trained in common law and who might have little or no familiarity at all with Islamic commercial jurisprudence, as it were. So I will just also go forward to answer in line with what I said, that this will entirely be on contractual and contextual and consensual agreement of the parties. And this will be in 3 stages. For instance, at the contracting stage, right? This is where Sharia will be strongest in its influence, because it is where the parties must have their control. And what it therefore means is that parties must ensure that they are well advised in terms of how to construct their Islamic finance transactions. And this will include them specifying the necessary governing law, and that the contract should be interpreted in accordance with Sharia principles.
That's very helpful,
right.
Mrs. Hulwer. Thank you very much. Can I just pick up on one point that you made, and that's in relation to the perhaps a lack of clarity in the jurisdiction of the Islamic law courts as relates to finance disputes. As we have the intersection of arbitration, is your point essentially that in the Nigerian context, the role is primarily on the parties to drive whether they want an Islamic arbitration process, and that they need to factor that into the arbitration agreement, because in the natural national legislative landscape, there isn't that kind of support or imposition of Islamic Sharia on arbitration.
Yes, essentially that's that's the explanation I had given. And like the jurisdiction that we have for the commercial courts here, and also what we have in terms of the Sharia courts. So, like I said earlier, we have basically Sharia courts that have not been given the primary jurisdiction to intervene in this type of disputes. And then we have the civil courts who have jurisdiction to actually intervene in disputes that have to do with commercial and financial matters. But the question that will arise is whether the judge who will be sitting will be well equipped with the knowledge of the Sharia principles to determine the Islamic finance disputes. So, yes,
yeah.
to answer your question directly, yes.
That's very helpful, and I think that experience is actually reproduced across a number of jurisdictions. The need for proper judicial training, and in the arbitration context, the need for well-trained and knowledgeable arbitrators who are familiar with the Sharia, with jurisprudence, the different madhabs, the textual analysis capabilities of understanding and reading the Quran and so on, and Sunnah. Mr. Asadullah, can you give us a brief insight for a few minutes, if you can, into the Mauritian experience? I know that I saw a map of Mauritius that would be quite nice to perhaps have in the background while you're speaking. I don't know if it's possible for our colleagues at the AIEC to put up that image.
Inshallah, my brother. Assalamualaikum warahmatullahi wabarakatuh, and good morning, good afternoon, and good evening, depending from which time zone you're joining us. Distinguished panelists, ladies and gentlemen. So at the outset, I would like to express my sincere appreciation to the organization, the AIAC, for their kind invitation to participate in this important discussion on Islamic arbitration in cross-border commerce. It is both an honor and a privilege to join such a distinguished panel of speakers and to share a perspective from Mauritius, and as well as a barrister in cross-border transactions. Before I answer to you, let me maybe begin by saying a few words about Mauritius and why it matters in the matter and context of cross-border commerce. So I will share that map in the meantime. So I'm sharing my screen. Let me know if it is visible.
Yes.
So this is also to our audience. So Mauritius has, over the several decades, positioned itself as an international financial center and a platform for cross-border investment. It sits between Africa, Asia, and the Middle East, and it has developed a legal and regulatory infrastructure that is deliberately designed to facilitate international transactions. Many of you will know Mauritius as a jurisdiction used for structuring investment into Africa, into India. Global business licenses, or as we call it, GBL, are incorporated in Mauritius precisely because the jurisdiction offers a combination of treaty access, regulatory flexibility, and a legal system rooted in both civil and common law traditions. So what is particularly relevant for our discussion today is that when these parties structure cross-border transactions through Mauritius, they inevitably need a mechanism for resolving disputes. And it is in this context that arbitration becomes essential, because the parties, they are from different jurisdictions, they use different legal systems and different commercial cultures that need a neutral and enforceable and efficient mean of resolving their differences. This brings me to the International Arbitration Act, which is the cornerstone of our international arbitration framework in Mauritius. The Act was enacted in 2009, and its stated purpose, which I'm quoting from the Act itself, is to promote the use of Mauritius as a jurisdiction of choice in the field of international arbitration, to lay down the rules applicable to such arbitrations and provide for related matters. The Act itself, it is based on the UNICITRAL model law on international commercial arbitration. This is significant because it means that our framework is internationally recognized, aligned with best practices around the world. There are three features that I will just mention briefly of this Act, which is particularly relevant to our discussion today. The first is that the Act places emphasis on party autonomy. So the party, they are generally free to determine on how their dispute will be resolved and what legal rule will apply to the substance of those disputes. Second, the Act adopts a strong pro-arbitration approach, limiting court intervention except where specifically provided by the legislation. This promotes certainty, efficiency, and confidence in the arbitral process. And third, which is the most important maybe for today's discussion, is that Section 32 of the Act provides that arbitral tribunal shall decide the dispute in accordance to the rules chosen by the party. This is significant because when we talk about Islamic dispute, parties are allowed to incorporate their Sharia principle, choose their IOF standard, or any other Islamic Sharia requirement into their contractual arrangement and dispute resolution framework. I refer these three processes as the Sharia arbitration triangle. So the question that naturally arises now, how does this Act together work with Islamic arbitration? And the answer, it lies in what I have just described, party autonomy within the Sharia arbitration triangle. Now, one important thing to know for our audience here is that Mauritius does not have a separate Islamic arbitration regime, unlike Nigeria, Saudi Arabia, UAE. We do not have specialized Sharia court. What we do have is an arbitration framework that is sufficiently flexible and internationally oriented to accommodate Sharia-compliant transactions. The International Arbitration Act provides a flexible framework. Its strength lies in not creating a separate Islamic arbitration regime, but providing a neutral and internationally recognized architecture within which the parties, they are free to incorporate their Sharia principle and their Islamic finance requirement into their transaction. In my view, this demonstrates that effective Islamic arbitration is not simply about referring the dispute to arbitration. Rather, it requires careful alignment between the contractual framework, the arbitration procedure, and the enforceability of that award. And it is this relationship between contract, procedure, and enforcement that I have described as the Sharia arbitration triangle. And I look forward to exploring these elements further in our discussion today. Thank you, and back to you, Dr. Faris.
Thank you very much, Mr. Asadullah. That was a very interesting overview, and how lucky Mauritius is to have you as such a proponent. But building on the substance of what you're saying in terms of the background of the jurisdiction, I think what you're saying is essentially that having frameworks in place, whether it's regulations, banks, other economic factors which are geared towards fostering Islamic and Sharia practices influence the underlying transactions and therefore make Mauritius an amenable place if parties want to opt in to having their disputes heard in the same jurisdiction. I think that's what you're saying, and that point was made very well. I'll pass on to Miss Horia, who's waited very patiently for her time. She has had the benefit of hearing everything that came before. But Miss Horia, we are very interested, as always, to hear about the Malaysian experience. So please, if you can, give us a few minutes of a snapshot.
Sure. It is worth that I preface the introduction to how Sharia is being applied in Malaysia by introducing to the audience watching this seminar or webinar on the Malaysian legal system itself. Because from I think at the time in the 80s, Malaysia had undergone a period of modernization through their legal reforms and gave birth to a recognition to dual legal systems called civil law and Sharia law. We are still considered largely a common law system, but for the purpose of differentiation with Sharia law, we will regard there's a civil conventional way, and there will be a Sharia law. So this is demonstrated by the Malaysian Federal Constitution, which provides that we have a list called state list and the federal list, where item 1 of the state list in the 9th schedule for the Malaysian eager to know which document says this, the Sharia matters are limited to Muslim individuals, and the authority lies with the state as a general rule. So commercial law, where Islamic finance has the most interface in, is placed under the federal list and remains subject to the federal framework. It is also worth noting that Malaysia also has a dual banking system. So we have a conventional banking system and also an Islamic banking system. These are codified through a Central Bank of Malaysia Act. We have a Financial Services Act on one hand for conventional banks, and we have an Islamic Financial Services Act for the Islamic banks in Malaysia. And where capital markets come in, we have some touch points on Islamic side at the Capital Markets and Services Act 2007. To ensure national uniformity for recourse to recovery or for disputes, we have 2 tiers of Sharia governance. So as sitting at the apex is our Sharia Advisory Council of the Central Bank of Malaysia, or colloquially known as the Bank Negara, for the Islamic financial institutions. And then we also have a Sharia Advisory Council of the Securities Commission of Malaysia for Islamic capital market activities. At the institutional level, Islamic banks have in place their Sharia committees for internal oversight for day-to-day operations or in relations to Islamic structuring of financial products. The application of Sharia within the Malaysia's arbitration framework, when we talk about arbitration, now it reflects a structured coexistence also between civil law and Islamic jurisprudence, particularly in the context of Islamic finance disputes, where the application is most concrete in Malaysia. Arbitration proceedings are primarily governed by an act called an Arbitration Act, which is procedurally neutral. They adopt their own Citra model law and have some revamp recently in 2005. But Sharia becomes relevant where parties have expressly incorporated in the contractual arrangements, right? So, but to see in practice is very much in Malaysia where everything's so proactively strategized at the internal corporation and bank basis. There's hardly disputes that actually go out of hand and ended up, having questions on whether the courts have had to decide whether whose jurisdiction is it under. There had been, but it was mostly at the earliest decision whether Islamic finance was the jurisdiction of the Sharia court or the civil law courts. So it's been decided that it is with the civil law courts, but because the judges, the judiciaries are not exactly, we have not underpinned them a training in Islamic or rather Sharia competency at the judiciary level. It's hence why we have the mechanism of a Sharia advisory council, because in Malaysia, Islamic financing structures are decided by the banks. So should there be issues with interpretation of Sharia laws, they usually take it up with the Sharia advisory councils. And these interactions are not open for the public. So not even lawyers like me would have known unless it got translated to a policy change by the central bank, right? So other than that, the various financing documents that I've done over the years are that rarely do arbitration is being touched, let alone the Sharia arbitration, because banks have a modus of recovery mechanisms embedded that will not usually require them to initiate a court case or even arbitration to begin with, unless there's an issue of fraud or misrepresentation from the bank itself or data privacy issues. Be that as it may, as I said earlier, arbitration by default and also by extension, Sharia arbitration gains their nexus through Sharia agreements or agreement for Sharia arbitration in the body of the agreements itself, right? So it's really, I've not seen it yet. I've spoken about this previously in another forum about on the where we see it in practice. But institutionally, we do have some rules in place by the Asian Arbitration Center, AIAC here, is that because they have set up arbitration rules for integration of frameworks that recognizes the practical reality of Sharia compliant transactions and to facilitate resolution within the arbitration. Um, uh, you can check out the rules on their website, and they have provided even a model clause on the Sharia arbitration with the manner on choosing the Sharia law, and really depending on the jurisdictions where the parties are agreeing, the kind of Sharia counsel and experts that you would parties chosen expressly to refer to in that arbitration clause. So it really depends to the counterparty signing at the end of the day. It remains open, and we're looking forward to at least the first few case studies on Sharia arbitrations in Malaysia.
Thank you, Ms. Horia. That's incredibly rich. That background has given me so much to think about and has presented so many different issues that, you raised the issue of dispute avoidance and actually how, if things are operating perhaps in their purest form, that actually you avoid a dispute coming to arbitration and it's resolved at an early stage. You raised points about jurisdictional competition between the courts and arbitration, which again is such a feature of arbitration the world over. But particularly with this issue, you do wonder in future as disputants, as parties become more sophisticated, more forthright about their own positionality and what they demand from an arbitration, whether they will actually start to produce more forthright arbitration agreements that provide for Islamic arbitration, Sharia compliancy, and so on. These are all highly important issues. One thing that you raised and you were talking about the two-tier system, the Sharia advisory councils, both in the banking context and the Securities Commission. Could you speak to if possible, just for a few moments, could you speak to the issue about the mandatory role of the Sharia Advisory Council and how that threatens or risks limiting or conflicting with arbitral autonomy and party autonomy in arbitration?
Oh, certainly, Dr. Faris. The Sharia Advisory Council framework plays a critical role in promoting consistency and certainty in Malaysia's Islamic finance arbitration landscape. That said, as I said, this remains anecdotal theory because the normal lawyers like me and you will not know this unless you've seen a policy change in the central bank, right? There had been one instance in history in Malaysia where there had been a buy bitaman ajil financing products in place, and then the Sharia Advisory Council made a decision, perhaps pursuant to an interpretation issues, that it's not Sharia compliant. So that's one very instance that I can speak of at the moment. Then the banks quickly, it didn't take too long for them to, take buy bitaman ajil out and insert tawaruk financing transactions in, because Malaysia is really quite a stickler for rules. So you take one, there's always another one. It's purely strategic, it's business as usual. But Malaysia thrives on regulatory certainty so that it's easy to make business. For Islamic finance, it's a no-brainer thing. Non-Muslims take up Islamic finance, right? For the role, I mean, if you have the questions on limiting arbitral autonomy, right? Well, the law says that decisions of SAC is binding, right? Because we don't, at judiciary in the courts, we don't have a competent Sharia trained judges unless and due to remember that I told you about the legal system, how they place the Muslim law, if it's states matter, if it's individual, if it's Islamic finance, it's still under the federal framework. Yes, so SAC is that apex for clarity and decisiveness in resolving technical issues. But the impact is that then the tribunals cannot independently determine Sharia issues once an SAC referral or a similar referral is required. So if you were to have an issue discussed in arbitration, you would need a distinction of facts or circumstances that give rise to the disputes in the banking agreements that also, while remaining respectful to not depart, to have a departure from traditional arbitration principle and the Sharia law. So, but then again, with the arbitration rules, tribunals can still retain control for procedure, evidence, and all non-Sharia legal and commercial issues. The other thing that is worth mentioning about the reliance on arbitration rules is that there's a certainty on how fast your conflict can be resolved, because they have a time period where you need to resolve this within, I think, 60 or 90 days. If not, there will be a binding award. So this puts a lot of certainty. I mean, again, because in the business landscape, you need this certainty for planning, for strategizing, and if the parties have shares or trading on listed exchange or stock exchanges, delay can cause valuation issues, right? So that's it, I think. I hope that answers your question. It's
That
more
does answer
centralizing
my
on
question.
certainty.
Yeah, that does answer my question. And I think maybe the takeaway point from all of that is that if you find yourself as a disputant at the intersection of those different jurisdictions in Malaysia, actually what you need is competent expert local law advice about how to traverse those two worlds and what might be available to you. So
Yeah. May I also add, because I think I forgot to say this, the arbitration rules also allow the parties to choose Sharia experts in another jurisdiction,
yeah,
right?
yeah.
But I think it's more appropriate and contextual to the subject matter of the financing products, because in Malaysia, it's very typical that Malaysian parties would choose Malaysian authorities to decide.
Yeah.
But in other jurisdictions, there can be there's always a choice to refer to IOFE.
Yeah. And then I mean that makes sense. And then we're back to the issue of choice and what parties are choosing and how they're making informed decisions, which is often something that comes down to the advice that they're getting, either from in-house counsel or from external counsel.
Yeah, that's right.
I want to go back to Mr. Asadullah briefly, if I may. Time is getting away from us, but I'm so intrigued by this Sharia arbitration triangle that you showed us before. We had the benefit of seeing it before our audience, but I want to invite you, perhaps in swifter terms than we'd originally envisaged. If you could just take us through the Sharia triangle that you mentioned in your opening as well, Mr. Asadullah. And my questions really are, I mean, I have so many questions to put to you about that, but to streamline it, I think the first one is, how do we deal with any uncertainty of conflict between terms of the contract and Sharia principles as governing law, and what practical measures we can take as an adjunct, what practical measures we can take to resolve that. And then we'll get to the enforceability part at the end, which I know is one of the three elements of the triangle. But please take it away and give us an overview of your idea on this.
So, thank you, Dr. Faris. So yes, definitely in my introduction, I did mention on the arbitration triangle. I'm sharing my screen so that our audience can visualize it as well, not just read my mind. So they have a pictorial view of how I have positioned it. So the central proposition is simple. Effective Islamic dispute resolution cannot be achieved through a single element in isolation. A Sharia-compliant contract alone is not enough if the arbitration process is unable to deal with Sharia-sensitive issues. Equally, a well-run arbitration achieves little if the resulting award cannot ultimately be enforced, right? So as I mentioned earlier, the contract is the foundation. So Faris, you ask specifically how to deal with uncertainties, how the parties minimize the risk of uncertainty or conflict between contractual terms, Sharia principle, and the governing law. And in my view, that begins with clarity at the drafting stage. The first and most important side of that triangle at the top is the contract itself. By the time a dispute will reach an arbitration, most of the important decisions have already been made. Indeed, many arbitration problems are not created by the tribunal. They are created by drafting. One frequent encounters clause stating something that I see quite often: this agreement shall comply to Sharia principle. At first glance, this appears very straightforward. This is a clause that many of us will put in our agreement. However, the immediate questions that comes after, from one being, which Sharia methodology are we applying? Which Sharia standard? Are we referring to an institution, Sharia Supervisory Board? Are we referring to the IOFE standard? Are you referring to a particular school of jurisprudence? What happens if scholars reach different conclusions? So these questions become particularly significant in cross-border transaction involving parties from those different jurisdictions. In a purely domestic transaction, this certainty may already be problematic. In cross-border transaction involving investors, financiers, counterparties from different jurisdiction, the issue becomes even more significant. The second issue is the governing law. Many Islamic contracts adopt English law, more or less. Maybe in Malaysia it will be Malaysian law, or in some Gulf countries it might be I think you're from Dubai, right? So that will be the UAE law that will apply to your case. And then maybe from Nigeria, they will have the national legal system, while they are simultaneously seeking for compliance within the Sharia principle. So that again raises another important question: is the Sharia adopted as the governing law itself? The distinction between is important because tribunal generally find it easier to apply identifiable legal system than broad and potentially divergent religious principle. This is where what I mentioned earlier, the Mauritian framework, our arbitration framework, becomes particularly interesting. Under the Section 32 of the International Arbitration Act, the tribunal shall decide the dispute in accordance with such rules as are chosen by the parties. This significance of this provision cannot be overstated. Mauritius cannot prescribe what substantive standard must be adopted. Instead, it respects the party autonomy, and the tribunal is required to give effect to those choices. Therefore, the Mauritian model does not impose any Sharia. Okay? And the final contractual issue that I see in many contracts, it concerns the arbitration clause itself. The party should at the beginning already consider the seat of the arbitration, the applicable arbitration rules, the language, the number of arbitrators, the appointment mechanism. So a poorly drafted arbitration clause may create years of procedural dispute before the tribunal can even reach its merit. And in my view, the certainty is one of the highest objectives in Islamic commercial law. The clearer drafting, the lower risk of future conflict. So I will stop on this first part, being on the contractual side. I will move to the second one, where you ask me the practical manners to resolve any procedural issues, right? That was the second answer that you asked me on that. And then we will look at the enforcement part of it to complete the triangle. So the first, this is where many theoretical discussions become practical challenges. The first one being the issue of the arbitrator selection. A tribunal can consist of highly experienced commercial arbitrators. However, if they don't understand the structure, for instance, if we're talking about Islamic arbitration, so they don't understand the structure of a murahaba transaction, a sukuk issuance, or a musharaka agreement, they may struggle to appreciate the commercial realities underlying the dispute. On the contrary, if we have a distinguished Sharia scholar that may possesses deep knowledge, deep religious knowledge expertise, but they are limited experience in arbitration procedure, the challenge is therefore finding the correct balance. This naturally leads to the role of Sharia expert. And in my view, Sharia experts should generally assist rather than replace the tribunal. Their role should be comparable to other forms of expert evidence. They explain the industry practice, the Sharia standard, the scholarly opinions, transaction structure itself, However, ultimate decision should remain with the arbitration tribunal. A further challenge that Sharia is not always monolithic, that is, different scholars may legitimately reach different conclusions. Accordingly, tribunals must be prepared to manage competing expert opinion. And this is not unusual. Arbitrators routinely evaluate conflicting evidence from accountants, engineers, even valuation reports. So this is not something that the Sharia is creating, and it's not an issue that Sharia is creating. Sharia experts should be treated similarly. Finally, I think the most important thing here that the Sharia sensitivity must not overcome at the expense of procedural fairness. The legitimacy of arbitration depends on equal treatment of the parties, transparency, independence, and fair hearing rights. Any departure from these principles may create difficulties at the final stage, that is the enforcement stage. The key takeaway here in the procedural section is that Islamic arbitration should not be viewed as an alternative to due process. Rather, it should combine Sharia sensitivity with internationally recognized standard and procedural fairness. And the third one now, we talk about the enforceability. So first there was the contract drafting. We look at the procedure and the fairness of the tribunal itself, now the enforcement. And ultimately, this is where the commercial reality prevails. Parties really rely on parties really arbitrate for intellectual satisfaction. They arbitrate because they require a practical and enforceable outcome. A beautifully reasoned award is limited to a value if it cannot be enforced against said. And here comes the New York Convention, which plays a critical role. It allows award to move cross borders and be recognized in different jurisdictions. And Mauritius, we have implemented the convention through the Convention of Recognition and Enforcement of Foreign Arbitral Award Act of 2001. As a result, any award rendered under the International Arbitration Act to benefit from the global enforcement architectures established by the convention. For Islamic transaction, this international enforceability is very essential. Nevertheless, challenges can arise. Question may emerge regarding public policy, mandatory laws, comparability with different legal systems. These issues become particularly important in transactions involving multiple jurisdictions. One of the key lessons that I have learned is that parties should think about enforcement at the beginning of the transaction rather after the dispute arises. And the choices are clear. You make a choice between which governing law you want to choose, between the seat of having your dispute, the tribunal composition, and the drafting. So that reduces the uncertainty, and those ultimately determine whether an award can be enforced effectively years later. So the key takeaway here, enforcement is not the final chapter of the story. It should be done it should be one of the consideration that shapes the story from the very beginning. And I end with that. Back to you, Dr. Faris.
That's very helpful, Mr. Asadullah, and highly interesting. I wonder if the AIAC can make this triangle available to all of our attendees, obviously with your trademark registered at the bottom. But it's highly revealing, actually, about the interrelatedness of the different components that you raise, and also, again, it's interesting to note that there are some familiar themes coming out. This issue about, how early on parties involve themselves in the drafting of their arrangements, questions of autonomy and preference, but also questions of knowledge and expertise, which are both in the beginning and also externally on the tribunal, or the experts, Sharia experts involved. I'm again very conscious of time. I want to allow sufficient time for the audience to share questions. I can see that we have one question already. But before I go to that, I just want to, if I can, put one more question to Mrs. Usman, who's been waiting very patiently. It's now Mrs. Usman's turn to wait very patiently until the end. And that's if she can give us some insight into the growth of Nigeria's Islamic finance sector, and also the role that institutions like her own, arbitral institutions like the one that she works for, can foster and develop credible Sharia-compliant infrastructure, which makes Sharia arbitration both accessible and durable for parties.
Yeah, thank you very much, Dr. Faris. And yeah, I waited patiently and I heard Mr. Asadullah's submission. And let me say that when I was hearing his submission, I had thought that, this is essentially what is applicable in most jurisdictions, including Nigeria. I didn't mention at the beginning that the Nigerian Arbitration and Mediation Act 2023, it's a robust law that repealed our 1978 Arbitration and Conciliation Act. And that particular act is essentially to bring a lot of development to the arbitration stage. And party autonomy is one principle that has been entrenched in the Arbitration and Mediation Act, the Nigerian Arbitration and Mediation Act. And what it means is also that parties who are designing a contract in Islamic financial transaction will actually be guided by the party autonomy principle, and also it will act to determine parties' freedom to determine the rules or the governing rules that they choose in their arbitration. So this is just important to mention. To go straight to your answer about the development of Islamic finance in Nigeria. Nigeria is, by most measures, Africa's most consequential jurisdiction in Islamic finance. It is one of Africa's largest economy, and its most populous country, and home to, I could say, one of the world's largest Muslim population, estimated at over 100 million, representing roughly half of the national population of Nigeria. So these are not just statistics to mention in passing. They are the commercial and demographic foundation of why Islamic dispute resolution in Nigeria matters. And this is not just to Nigerians, but to the global Islamic finance industry. This is particularly essential also because the Nigerian framework for Islamic arbitration has, like I said earlier, remained underdeveloped. But what we have is actually the Arbitration and Mediation Act, which essentially can also cater for what's the disputes that will be arising within that within the ecosystem. I have mentioned the dualistic and the pluralistic nature of our legal jurisdiction. So, but the Nigerian Islamic financial journey actually started in earnest when the Central Bank of Nigeria issued its framework guidelines for non-interest banking in 2011. And followed by that, a non-interest Islamic bank was for the first time licensed to operate in 2012. Then we had some other Islamic windows that were opened to banks such as the Sterling Bank and the Stanbic IBTC. But over the years and in the last 1 decade, we have had banks such as the Taj Bank, the Lotus Bank, subsequently joining the sector. And in recent times, the Debt Management Office of Nigeria have issued sovereign sukuks differently. So this is all, and so much other is the development of Islamic finance in Nigeria. In fact, in recent developments, as recent as 2023, the Central Bank of Nigeria issued a circular mandating all non-interest banks to establish a Sharia review or compliance function, reflecting a maturing regulatory expectation for the Sharia governance within the sector. Most significantly, in May 2025, we have the CBN of Nigeria introduced 3 new Sharia-compliant financial instruments, like the Nigerian Non-Interest Financial Institution Master Repurchase Agreement, the CBN Non-Interest Asset-Backed Securities, CNI ABS, and the CBN Non-Interest Notes. This is all to address the long-standing liquidity management challenges that the sector had encountered, and to deepen the integration with the broader monetary policy framework. The Arbitration and Mediation Act actually represents the most significant reform of Nigeria's dispute resolution framework in decades. Like I said earlier, it repealed the Nigerian Arbitration and Conciliation Act of 1988, and then domesticated the New York Convention, just like we have in the Mauritius. So our Arbitration and Mediation Act was modeled after the UNCITRAL commercial arbitration law. But to recognize this, or let me just say that the particular interest is that the Arbitration and Mediation Act of 2023 is a general commercial arbitration framework. It does not specifically address Sharia compliance, right? And then Islamic jurisprudence, or the unique features of Islamic commercial transactions, just as we have, and just like Mrs. Huria have mentioned in what is applicable in the Malaysian jurisdiction. It is also what is also applicable in the Nigerian jurisdiction. So far, parties will have to fall back to their contracts, and that's why it is essential that at the beginning, like Mr. Asadullah said, it is essential that at the beginning the contract is structured in a way that it can accommodate the Islamic principles when the dispute is being resolved at the end of the day. So, but what Nigeria needs currently, right, I will just mention, is that now we have the Arbitration and Mediation Act is being reviewed, and it will be an opportunity for us to incorporate those in some part of the act, the applicable Sharia principles, or the opportunity for parties to be able to choose whether they want a party, an arbitrator who has the dual competence of both commercial competence, and also the understanding of the Islamic jurisprudence. So this is what we're looking at. And for centers like us, the Nigerian Chambers of Commerce Dispute Resolution Center, I think this even provides an opportunity for us to establish panels of arbitrators, to have in our role of arbitrators, in our roster of arbitrators who actually have the dual competence of both commercial competence or commercial understanding, both in Sharia and also the ability to apply the arbitration procedure properly. So for us, I think this is an opportunity for us, and I think not only for a mediation and arbitration center like ours, but generally arbitration and mediation centers within Nigeria. We do not have to begin to have new legislations specifically for Sharia dispute resolution in Islamic finance transactions, but we should be able to provide a pool of arbitrators to be able to cater for this industry at the end of the day. I will also add that these are steps that we will take because this is important to us. And with what we already have, we do not need to reinvent the wheel. The Asian International Arbitration Center already has its arbitration. So all that we need to do is to look at what they already have and see how it can be replicated or beneficial to us by also reinventing, by not just reinventing the wheel all over, but picking up from what is already available and ensuring that we have something that is workable within our jurisdiction. So essentially, I think that's what I will have to add. And the fact that for dispute resolution centers such as our own, this is essentially key for us. And I think this discussion is particularly timely. And the fact that whatever is that we're facing or we feel is the gap that we have is actually also a gap that other jurisdictions have experienced and have been able to innovate ways to actually fill it up. And just like all the other jurisdictions, even in Nigeria too, what we also have is that the central bank essentially makes it mandatory for all the Islamic or the non-interest financial institutions to have the Sharia board that will give the necessary advisory or necessary advice whenever issues as to the principles come up. So, but in terms of specifically addressing the dispute resolution, then it is essential that we begin to develop that pool of arbitrators or pool of dispute resolution experts who have the dual capacity to deal with both the commercial certainty, because this is where building the confidence in investors will come. The fact that they know that at the end of the day, there are experts, there are competent dispute resolution experts that will resolve such disputes. So whether it is a domestic dispute or it is an international dispute, what is important is that it is available. What is going to be required? The role it's actually available. We have the pool. We already have a lot of Nigerians who are scholars in the in Islamic jurisprudence. And just to mention that we have the Secretary General of the OIC Arbitration Center, who is a Nigerian and an expert in Islamic finance and Islamic finance dispute resolution. So with this kind of people, like just to mention Dr. Hosseini Umar, we will know that it will be easy for us in Nigeria to develop the capacity that is needed. And once we have the AIAC, the Asian International Arbitration Center, collaborates with other centers in the other jurisdictions, then it will be essentially easy for us to replicate what is already available. So the industry is growing fast. The dispute resolution mechanisms are also already there. The system is already developed, and that all that we need to do is to do a little catch up to ensure that the ecosystem of the dispute resolution also catches up with the development in the Islamic finance industry in Nigeria.
Thank you so much, Mrs. Usman. That is a perfect tail off to the contributions. We will now make the most of our time remaining to answer some of the questions that have come through. I'll hand over to firstly to I'm going to put her on the spot now, Miss Hurriya. I'm going to put you on the spot with a few of these. I'm happy to jump in and help.
Sure.
And we can do them together if you like. The first question is Islamic arbitration the same as arbitration as per Islamic law? That sounds like a philosophical question.
Also,
Yeah,
that actually warrants some competency as well, because I'm only an Islamic finance transaction lawyer. I'm not
sure.
Sharia qualified in Malaysia, though
That's okay.
trained.
Yeah.
But in my view, if I were to draft a document and be presented with the same question, I'm going to say no, just purely on the surface level. But because Sharia always, it's not, the lens that we are looking at is always not what Sharia restricts, but what Sharia provides, right? So it's a very forgiving system where as long as it's not detrimental or contradicting the Sharia, it can still be called Sharia compliant, but subject to confirmations by the Sharia
Brilliant.
experts. And it also depends on jurisdiction to jurisdictions,
Very good.
depending when you're talking about. So that's my take on how we see.
That's really helpful. I would just add to that, and this is my quick reading of that Islamic arbitration. I think, or I take to mean the umbrella that I referenced at the outset of the panel, and I think which Miss Hurriya adequately described now as kind of a vast array of different customary, cultural, procedural, substantive issues that might influence the arbitration at different points. Whereas Islamic law, to me, triggers ideas and notions of applicable law. And I've seen this in a number of contracts, not just in the UAE, but across the Gulf, across the Middle East. So the governing law of the contract is Islamic law or applicable rules of Sharia. And that's quite common. And then, of course, how do we give that credence? How do we give that its true meaning? There are lots of indicators there. I mean, another question I've seen here from Surinder Kumar under Islamic law, which laws are applicable for the law governing the contract, the law governing the arbitration agreement, the law governing the arbitration procedure, the law governing the arbitral award. I mean, again, that question's very broad, but very good in that it breaks down the different components of what we mean by law and where Islamic law elements can arise. But how we determine these things will be in a number of respects. I mean, look, you can start with the national law and where Islamic principles infiltrate or underpin the national law. You then have industry-specific legislation and elements of Sharia or Islamic law that might impact that legislation. You then have constitutional law elements, whether it's arbitrability or otherwise. You then have public policy elements, whether if the public policy of the state where the contract was or is being performed is an Islamic law country, or where Islamic law forms a main source or principal source of legislation. There are, of course, public policy elements there. I mean, there's a lot there to discuss, but that would be my take. So the answer to the first question is Islamic arbitration is the umbrella term. Islamic law speaks more to applicable law or procedural law. Any comments on Islamic third-party funding in promoting Islamic international arbitration? That I will give to Asadullah. We're still giving Mrs. Usmana a break for a moment.
Thank you, Dr. Faris. That's an excellent question, and I think this is an emerging area with significant potential. The question is whether the funding structure itself is Sharia compliance, particularly from the perspective of riba, gharar, and speculation. If properly structured, Islamic third-party funding can improve access to the justice and make the Islamic international arbitration more accessible, especially in high-value cross-border dispute. In short, I think the concept is promising, but the Sharia compliance of the funding arrangement itself is critical.
Brilliant. I'll stay with you, Asadullah, because we have a specific question in relation to your triangle, which it sounds like is going to become a famous triangle for now after the presentation. But someone's asking, as far as I understand from Mr. Asadullah's triangle, parties can agree on Islamic principles in addition to the governing law of arbitration, governing law of the arbitration agreement. So can we say that this is Islamic arbitration, or are there other factors?
Okay.
So
I
I
think I should
understand
have.
that question to mean, can the parties agree on Islamic principles in addition to the governing law of arbitration being Islamic law? That's how I understand the question.
Yeah.
Well, I would guess that first I should have trademarked the triangle before the presentation. Um, but the triangle is a conceptual framework. There are definitely other factors that may be also relevant when determining whether a process can truly be described as an Islamic arbitration. And as I have mentioned, they may include the qualification. I think I mentioned the choice of the arbitrators, but if we go a bit in deep, so maybe the qualification and the Islamic expertise of the arbitrators. If we are having an Islamic finance transaction, maybe what is their Islamic finance expertise? Um, the degree of Sharia supervision within this arbitration process, that's also very important, if we want to follow, because Islamic principle also tells us segregation from men and women. So that's also within the whole process if we want to make that a purely Islamic arbitration. Then I would say maybe as a last comment, maybe the enforceability of the award, where Sharia consideration may be relevant. If we're talking about different countries, like I said, Malaysia has some laws, UAE have some laws. If we talk about other countries like Afghanistan, Syria, Iraq, everyone follows a different process and different influence. But ultimately, we'll just end with this. The triangle focuses on the three core pillars of the contract, procedure, and the enforcement. It does not exclude any other factors.
We're getting it. Thank you very much, Asadullah. We're having some comments through. Some people seems like they were very pleased with what Mrs. Usman was saying about the roster of arbitrators, of cross-qualified arbitrators. And they're saying that it was a good sharing of perspectives, and doubling down on Ms. Usman's view that there's scope for centres to collaborate in joint panels of arbitrators and subject matter experts. I mean, just to expand that out, I mean, that's also possible, just speaking from personal experience. It's possible between arbitral institutions that operate in Muslim majority countries and arbitral institutions that are in non-Muslim majority countries. And one example is the Tashkent International Arbitration Center in Uzbekistan, which has cross-institutional rules with the HKIAC in Hong Kong. I think that was probably one of the first institutions of its kind to do such a thing. But that's an interesting take. I mean, still, they don't have the TIAC, neither the TIAC nor the HKIAC have the arbitration rules that the AIAC has, for example. but that cross-institutional collaboration point, and as Miss Usman mentioned, the pool of arbitrators and so on is a fantastic point, because yeah, I mean, giving people confidence, making them aware of who their decision makers are, maybe making sure that people get out and about and meet their experts is incredibly important for engendering confidence in the system. There's a request here from someone for career advice, which I'm very, very sorry, career advice in the GCC region. I assume that's directed at me, although I mean perhaps our panelists can also give advice on careers in the GCC. But you know, for my part, I'm very happy to give careers advice to that person if they would like to contact the organizers at the AIAC. I'm very happy for my email to be provided so we can have direct exchanges. More than happy for that. And I think I'll just give a few more moments to see if there are any other questions.
I think we have one more question coming from, I think, Dato Danesh. Wow, there's actually more. The list builds up.
Right.
We're dealing questions. I think it is the question where it refers the AIEC rules as foundational framework. Are you seeing that question? Yeah.
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 Please go ahead, Miss Cordelia. Please go address that.
Oh,
if you
right.
like.
Let me read the questions. So, the question revolves around whether AIAC as a Islamic arbitration rules could serve as a foundational framework for the development of a common protocol or harmonized set of Islamic arbitration rules among arbitral institutions, especially within the OIC countries. So the question asks for all panels' view, and if there's also a scope of participating centers to collaborate in establishing a joint panel of arbitrated subject matter experts. I think you briefly touched on that earlier on the case on the real case study on Tashkent Arbitration Center with HKIAC, right?
Mm.
Yeah, but anyone else, Miss Usman, would you like to give your view?
Yeah, I think it's Dr. Faris actually mentioned and had seen that as an addition or a follow-up to what I have said. I think let me just mention that in November of 2025, the OIC Arbitration Center in Istanbul had actually started this. I was privileged to attend the OIC arbitration, AC arbitration days, and we had this forum, the forum of ADR centers or within the OIC arbitration states. And the whole essence is to actually develop this. And I think not only just in Islamic finance arbitration practice, but generally, even in investment disputes and other disputes that are relevant to the region. So collaborating to come up with robust frameworks for practice is actually an important step to take for every jurisdiction. And for us, we are more than happy to be in such kind of engagement where we develop this particular framework. And like I said when I was making my last submission, this is the kind of things that give investors confidence, whether they have investors within the Islamic finance practice or generally investors who go to other jurisdictions to invest their money. The fact that they know that there is a collaboration and that they can decide and take and choose who to be their arbitrator when the time comes gives them the confidence to want to actually engage. right? We've talked about judicial certainty. We've talked about commercial certainty. So these are the kind of collaborations that ensure that there is commercial certainty or that there is the buy-in across board of investors confidence at the end of the day, that when disputes arise in the course of their investments, they are certain that they could come, they could choose any of the jurisdictions. So the AIAC is in Malaysia. We are in Nigeria. But now, since COVID-19, we know that people don't have to travel miles to do arbitrations, right? People can stay in their states without the cost of having to travel, but to engage in any type of arbitration they want to. So this kind of collaborations will essentially mean that parties can decide, even if they're in Nigeria and in a cross-border transaction, to choose the AIAC as its arbitration procedural framework. The arbitration rules can be chosen from any part of the world. So for me, I think that this is essentially important, and that is why even this conversation is key to what we're discussing. This is where it starts from. Mr. Asadullah is joining from Mauritius. Dr. Faris is joining from the UAE. Ms. Huria, you are in Malaysia, and I am in Nigeria, and we're having this conversation. What it also means is that panels of arbitrators can also be in this different jurisdiction and still be able to cater for the services of the cross-border transactions that will happen within the Islamic finance framework. So it is a community that have to be built for jurisdictions like Malaysians that are already ahead of jurisdictions like Nigeria. It is only a collaboration like this that can actually make sure that we upscale and we give the confidence that investors need. So this is important, and I think it is a step for us to take.
What a brilliant way to bring the panel to a close from you, Mrs. Usman. That was a wonderful tour de horizon of the dunya as a whole and our place in it. And just to add to the diversity of it, I'm in the UAE via Palestine. So it's important not to forget Palestine.
Oh, wow, that's great. Good.
There are so many more questions. I mean, I can see here there's a conflict of law question from Maham Abrar, which is a Pandora's box. I mean, what a brilliant question, but that has to be maybe the subject of another panel if everyone will have us back. But I'm incredibly grateful to everyone. And just a final point to draw the panel to a close and to try and take stock of what we've heard today from the brilliant experts and panelists. We've heard so much about party agency, party preference, party power, stakeholder control, the capability to determine arbitral references and reliance on Sharia principles. That's been a recurring theme throughout all of the answers that we've heard from our panelists today. We know that a current hot topic in international arbitration is party conduct and how we as a community can manage and govern proper and professional conduct in arbitration. This seems to remind me somewhat of the position that Islamic finance was in shortly after the global financial crisis, where people turned to Islamic banking, Islamic and Sharia-compliant banking as an alternative to the vagaries and the difficulties of the alternative financial system. And I wonder whether we are standing at this point in time at the same or a similar point in respect of our uptake of Islamic arbitration, whether we now consciously as practitioners, as institutions, as parties, need to be more forthcoming about our use and utilization, and the power that we hold to decide and impact on the use of Islamic principles in arbitration and Sharia. And so with that as a final statement, I'll hand back over to Ms. Freen and the AIAC, thank them again for their brilliant organization, and thank you again to all of the audience members for participating.
Thank you so much, Dr. Faris, and thank you so much to all of our wonderful panelists for such a comprehensive session. So, ladies and gentlemen, with that, we now unfortunately have come to the end of today's webinar. Thank you so much for your support and participation in the event. We do look forward to hosting you in our future Islamic arbitration webinars. Thank you very much, and hope you have a nice evening or afternoon ahead. Thank you.